Sasken had this contract signed in 2005 with a Chinese company to license some software product. Around 2012, this Chinese company turned around and said, we are no longer using your product, and so we will not pay you any more royalties. So the next thing we did was we bought their products from the market, reverse engineered it, and found that all our IP was in their products. So now you know that they're using your IP. So what do you do next? We looked at the contract. It provided, luckily, in our good sense, 10 years ago, we had said institutional arbitration. The institution we had picked was American Arbitration Association, AAA, and the laws were Californian laws. So here's a Chinese company and an Indian company agreeing to institutional arbitration in the US. Okay? Not a great situation, but under the circumstances, I think it was far better than litigation. Can you just imagine if we didn't have arbitration, where we would have fought that? In China? Any hopes of getting justice there? Nothing really, right? In India? Oh, it could have dragged on for years. So we actually were lucky that, we had said California. Now let me explain how the time worked. So July, they say we don't use your IP. By September, we confirm that our IP is in their products. We negotiate with them for appointment of an arbitrator. Takes about 90 days. As usual, if you're in dispute, you're not going to agree to the arbitrator, right? So you're going to fight even about the arbitrator, and you're going to drag it. Here's where the institution steps in. Institutions normally have a list of arbitrators, and they have a method by which an arbitrator can be selected. And the method that was used, which I can share with you, is the AAA gave us a list of 10 arbitrators. And each parties had to score out the ones that they did not want. And from the ones remaining, you had to rank them 1, 2, 3, 4. Who's your most preferred? Who's your second most preferred? Both parties did it independently, gave it back to the institution. The institution picked the arbitrator who had the best scores. Can you see the merit in this method? So the person picked is liked by both parties, and so they're likely to abide by what that person is doing. Okay? And before you select, they give you the CVs of all the arbitrators. So you've got enough time to think. 90 days, arbitrator appointed. Another 30 days, he sets up a call. It's called an administrative call. Can you imagine any judge asking for a call? You have to all travel, right? This was in California, one party in China, one party in India, lawyers in California and the arbitrator in California. Call set up. In that call, for the next 12 months, a schedule is agreed. And the schedule has milestones every month, which says, in 1 month, each of the parties will tell us what are the documents you require from the other party. It's typical disclosure. Right? Any document that is going to be used in the arbitration has to be shared with the other party. So you can't spring any surprises. So there's a timeline. 30 days, document disclosure. 90 days, I'm giving you an example. 90 days, who are you going to use as fact witnesses to that entire dispute? For example, if it's relating to a contract, who negotiated the contract from your side? Who negotiated it from their side? Are you going to present them as fact witness? Please submit their statements, and those statements are submitted to the other party and to the arbitrator. So notice here that information is shared with the other party, nothing is held back. Do you see the merit in this? There can't be any surprises later. Right? Okay. Then there's time for each of you to respond back if you have any issues with the fact witness statements. Then there's a timeline fixed for if you want to bring experts. So if I want to prove that my IP has been used by the other company, then you call an external expert of repute to evaluate it and to share their findings. Another timeline for that. Like that, there are timelines and everything is done offline. We had only one set of hearings in California when all of us traveled. which was 1 week at a stretch. Now, can you imagine what this does to your costs? You don't have multiple hearings. You don't have people traveling up and down. One set of hearings, 1 week at a time, and we are told, please keep an extra week as backup. The arbitrator tells us that. If we need to extend, we will use the second week. And all of this has happened like within 12 to 15 months. In 15 months, you get your award, and in the next 1 or 2 months, the dispute is over. Whichever party needs to pay, pays. The chapter is closed. I don't know if any of you have experienced such speedy resolution. And it is because of this experience that I actually got back to thinking about why did we have to fight this in California? Why couldn't we have done it in India? Why is institutional arbitration better now? What are the changes that are happening in the law? So the first thing is that arbitration was becoming as time-consuming as the court process in India. Right? And that was because for everything we would go to the court. If I don't like the arbitrator, I go to court. The court takes years to appoint an arbitrator. Then if I don't like the award, I go to court. The award is set aside. So for everything, I could run to the court and delay things. So that should now change with this 246th Law Commission report and changes to the Arbitration and Conciliation Act. Right? Institutional arbitration is getting promoted, so quality of arbitral awards is expected to be better. Costs are being controlled. So those who've experienced courts will know that your court fee is 7.5% of the dispute amount. Right? And then you have to pay your lawyers. But you go through arbitration, the cost is, I think, in the range of about 5% of your dispute amount, and it gets settled in like 2 years. So should the changes actually get implemented into a new act, I think we'll be in a far better situation than we have been in all these years. So really, the point we are making is that please go back and look at your dispute resolution mechanism in contracts. Please begin right now to have institutional arbitration as a method of dispute resolution. Over the years, there will be issues. The law will keep getting changed, hopefully for the better. And then, not only can we get our disputes resolved quickly with low cost, we also reduce the burden on the judiciary.